Damn it, Janet, stop charging by the hour.
Hi there, this is Janet Gershon-Siegel for Semantic Shenanigans Extras. Today I'm going to be talking a bit about the Seuss versus David Gerrold et al. Case that has come up. There's a little something that has happened recently. I apologize for not being around very much. Actually, in the last month or so, my own business, I'm a freelance writer and blogger, has suddenly really taken off. So I just plain don't have the time to devote to very long and drawn out discussions about these things, unfortunately, because I do it for money now. But be that as it may, and also Shanna is off enjoying the summer. God love her. So she's a busy gal too. Anyway, to get to the ComicMix case, I wanted to talk a little bit about the hearings and orders that have kind of come down recently, and they have gone through semi-mainstream media. Interpretations are, I think, a little they're a little on the overly optimistic side in terms of what happened with the defense. So I did want to clarify that. One thing I think people need to understand is that most cases don't get any media attention at all, and if they do, it's often minimal. So that's one of the reasons why this hasn't been this media fest like the Axonar matter had been. And the other thing I wanted to point out is that law firms they win and lose cases all the time. They win and lose motions all the time. And there's absolutely nothing wrong with it. It doesn't mean that you're a bad lawyer if you lose your cases on occasion or you lose your motions. And it doesn't even necessarily mean you're such a fantastic lawyer if you've got a really good record of constantly winning, because you got to dig a little deeper into the data. A person who is has this fantastic, batting 1,000 kind of a record for either cases or motions, it either means that they're just doing easy stuff, or maybe they're really new, so they don't have a lot of things, or it's the kind of stuff that's really kind of these foregone conclusions. And when you've got sort of these foregone conclusion kind of cases, like your client was rear-ended in an auto accident, let's say, very often the judge will get kind of upset about that. At least that's been my experience in practice, because when they're that one-sided and obvious, that sort of thing really should never come in front of a judge. It should have been handled by a claims adjuster, where money is either offered or it's not offered, and then we're all done. And it never sees a courtroom, and the judge never sees it, because let's face it, it's expensive to put stuff through courtrooms and hearings and motion practice and trials and whatnot. And if a judge sees that a case was really easy and was really one-sided, a judge is going to get kind of upset, because they just don't want to waste their time with that. So what we had here in the Seuss ComicMix David Gerrold case is much like we saw in Axonar, and we see this in a lot of cases, where both sides move for summary judgment. And essentially what defense said was that, first off, they said it was fair use. They also said that the plaintiff had trademark claims, and that those should have been denied, and that the plaintiff was also claiming unfair competition. Now, to refresh your recollection a little bit about this, this case was about a book which has not been published yet, called "Oh, the Places You'll Boldly Go." And it used images that looked a lot like Dr. Seuss kind of images, the font, the characters, the coloring, the brushstrokes, and whatnot. The inking, all of that stuff looked a lot like Seuss. It really screamed Seuss, but the costuming and whatnot, the apparel that the characters were wearing and all that stuff looked like Trek, and a lot of a lot of the dialogue was very Trek-oriented. Now, the owners of the Star Trek IP, CBS and Paramount, they did not sue. They are not a part of this case, so keep that in mind. It's only the Seuss estate which runs Dr. Seuss Enterprises. They're the ones who sued here, and they said it's a copyright violation, it's a trademark violation, and it's unfair competition. And very recently, during this month, in June of 2017, on the 9th, an order came down. And it was an order, about these motions for summary judgment, and this order has been stretched beyond its limits because people have been saying, "Hey, look, they won their case." No, they didn't win their case. Oh, look, the case is over. Nope, the case isn't over. Here's what happened. Here's what really happened. The judge said the following. Judge said, first off, can't really decide as a matter of law whether there's fair use here. So because I can't decide whether there's fair use or not, this case should continue, because if it's not as a matter of law, if there's a matter of fact there that has to be decided, then that goes to a trier of fact, which almost always is a jury. So let's just start with that. That means case continues. The case survives. Secondly, it also said, this order also says that the copyright infringement claim survives, that it stands. And again, this is because the question of fair use has not been decided yet. Thirdly, the court did decide on the trademark infringement portion of their program, and they said, first off, they said plaintiff does not oppose the substance of defendant's trademark-based argument regarding nominative fair use. Therefore, the court grants the defense's motion to dismiss the plaintiff's claims of trademark infringement. In addition, the court also granted defendant's motion to dismiss plaintiff's claims of unfair competition. So basically, what happened is that this case started off being tripartite. There was a copyright claim, there was a trademark claim, and there was an unfair competition claim. The latter two were long shots for the plaintiffs, big time long shots. Defense moved for summary judgment, and the court agreed, but only with reference to those two pieces of this case. So the two pieces of the case, which were, like I said, they were long shots. It was not likely that plaintiff was going to be allowed to bring these to trial, that they were probably not going to survive. Just as expected, they didn't survive. So what happened here was not some grandiose precedent-setting ruling here. Instead, what happened was exactly what was expected. And what was expected was that the two weaker portions of the plaintiff's case were dismissed exactly as would have been predicted. The stronger portion was kept, and now we continue on. The court also said that the complaint has to be amended in order to, in particular, plaintiff really didn't give a nominative fair use opposition. The defense failed to respond to plaintiff's confusingly similar titles argument under a case called Rogers versus Grimaldi. So, therefore, the court also granted the plaintiffs leave to amend their complaint regarding the second and third causes of action. This is under a case called DeSoto versus Yellow Freight Systems. And the holding in DeSoto was that a court should freely grant leave to amend, quote, unless the court determines that the allegation of other facts consistent with the challenged pleading could not possibly cure the deficiency, end quote. So essentially what had happened here is, like I said, 1/3 of this, the strongest third of this case remains. Plaintiff has been told they can amend their complaint, and they should, because they're being granted leave to do so. You shouldn't just rest on your laurels. You should be amending this complaint. So I would imagine that we would see an amendment to the complaint fairly soon, probably before August 1st would be my guess. And the case continues on. It hasn't ended. Nobody really won the entire case. The case is not over, and this did not make enormous amounts of precedent. This is not one of these things that's going to go down in history, like Roe versus Wade or Brown versus Board of Education of Topeka, Kansas. So despite what you may have been hearing or reading in the press or in other blogs or any other places, this is a victory for the defense. I'm not going to tell you that it's not, but it's not a very large victory for the defense, and it's an expected one. So we continue on. Once again, this is Janet Gerson-Siegel for Semantic Shenanigans Extras. I am going to blog about this, but again, it's going to be really short. And a lot of these blogs and these extras are going to be short from now on because I just plain don't have the time. It's nice to be successful, I'll tell you that. But I do miss interpreting the law for you. So, but I will try to do what I can over the summer. Anyway, take care. Thanks for listening. And bye for now.
Music provided by Invocation. Send mail to hosts@semanticshenanigans.com. Follow us on Twitter at 2shenanigans. That's the number, not the word. 2shenanigans. On Facebook, you can find us at Semantic Shenanigans. Subscribe to our YouTube channel, Semantic Shenanigans. Thank you for joining us, and we'll see you next time right here on Semantic Shenanigans.